Hello and welcome to Conversations with Esther tonight, the 9th of April 2025. We have our guest in the room, Honorable Lady Justice Jacqueline Kamau. Thank you, Lady Justice Jacqueline, for making time. I know your day was quite busy. Audience, excuse me, my camera will be off. Unfortunately, I have a technical hitch, but we will still go on. Allow me to pray. Father, in the name of Jesus, we thank you for this session. We pray that you will lead us and guide us, and that we will learn from our very valuable guest. We thank you in Jesus' name. Amen. So I will talk to us about conversation, and especially for those that could be joining us for the very first time. Allow me to put up a presentation right on the screen, just as an intro for Conversations with Esther. Right there. I hope you can see my screen. So we are Conversations with Esther, and I am Esther Katiba. Those are our social media links. You can scan that and you'll be able to view our screen and our social media handles. That's our YouTube, our LinkedIn, and Instagram. So Conversations with Esther is an impact-driven professional platform that informs, educates, and rebuilds mindsets on matters around work, organizational culture, and holistic wellness. Now, we ignite ethical and authentic leadership, promoting best practice within industries. Conversations with Esther equips the workplace with relevant legal, human resource, and holistic wellness skills through capacity building, training, motivational talks, end-to-end HR consultancy support, and mentorship programs. Now, we are guided by three values: integrity, excellence, and impact. We envision a workplace transformed by candid conversations, respectable relationships, and intentional leadership. Now, Conversations with Esther is big on holistic wellness. We encourage the people in the workplace and in the community to prioritize their wellness. We speak to you on physical wellness, mental wellness, financial wellness, social wellness, spiritual wellness, environmental wellness, and intellectual wellness. Now, those are our 7 pillars of wellness. We help organizations to customize wellness programs. We give talks to organizations, and we do training for organizations on wellness. We also have events on wellness. We just had a very successful nature walk at Karura on 29th of March. And thank you to everyone that showed up. We had around 30 or more people show up, and it was an amazing activity. Now, 26th of April, we have a team building and networking event. We will be sharing our links on the chat. We have a physical wellness event on 31st of May, environmental wellness in June, a hike in July, facing our fears, and with having daring activities on 30th of August, movie and bowling day, 27th of September, mental health awareness event, 25th of October, and close the year with a dinner and awards for wellness champions in November. You're invited to these events. We will be giving you more updates as the dates get closer. Today, this is what we are talking about, and I'm glad that we are 39 or going 40 in the room. Alternative justice, mediation and alternative justice system. I said we have the right person in the room. Very, very professional. We have Lady Justice Jacqueline Kamau, High Court Judge and former President, Kenya Magistrates and Judges Association. And this is the question we are asking. What is the role of mediation and alternative justice systems in Kenya? Most of you have interacted with the Constitution and Article 159 says this: alternative mandates the judiciary to promote alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms, subject to clause 3, which states traditional dispute resolution mechanisms shall not be used in a way that A, contravenes the Bill of Rights, B, is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality. And there are some people that tell me, you know, Esther, these terms of yours, Lady Justice Jacqueline is in the room, is inconsistent with the Constitution or any written law. Now, allow me to introduce our guest. And today we are going to have a very different format. And I know most of you know that usually we do a PPT, but today we've decided to interview our guest, Lady Justice Jacqueline. And I want to give you a profile background of our guest, Jacqueline. Lady Justice Jacqueline Kamau is a presiding judge of the Vihiga High Court in Kenya. She holds a Bachelor of Social and Legal Sciences and Bachelor of Laws, that is LLB first class, from the University of Pune in India, Diploma in Law from Kenya School of Law, and Masters in Medical Sociology from the University of Nairobi. The experience that she has gained in serving in different committees of diverse interests has seen her present papers on a wide range of topics in conferences, workshops, and seminars, domestically and internationally. Now, Jacqueline is a fellow, and when I read it this way, Lady Justice, when you give me a profile and I say Jacqueline, I feel like I am not respecting the seat. Lady Justice Jacqueline, allow me to add that, is a fellow, chartered arbitrator in Chartered Institute of Arbitrators, and accredited tutor with training from the Chartered Institute of Arbitrators and Center of African Peace and Conflict Resolution of the California State University, that is USA. She has tutored innumerable number of participants in arbitration and mediation, many of who have now attained fellow and chartered arbitrator status. She has contributed a chapter in arbitration law and practice in Kenya and written articles in several journals. She is also a director at Strathmore Dispute Resolution Center and a member of the Asia Pacific Mediation Forum representing Kenya. Recognized for her work in alternative dispute resolution, Lady Justice Jacqueline received the award for Outstanding Woman in ADR 2024 from Women in ADR. The same year, she received awards for leadership and pioneer women in ADR. She has a passion of pursuing academic excellence. That is our guest tonight. As I stop sharing, I know I want us to look at Lady Justice. Hello, Lady Justice Jacqueline. How are you?
Fine, thank you, Esther Katiba. First of all, let me thank you for that very wonderful profile that you read out.
Yes.
Sometimes you start wondering whether you got a few points from somewhere else, but thank you very much for that kind of profile. And for everybody who has attended, I just really want to thank everybody. I feel very humbled that about 44 persons have felt that there's need for them to learn something new that is not within their area of practice. So I'm extremely delighted to be here. Thank you very much. And thank you for inviting me.
Thank you. Thank you too for honoring this invitation. As I said, today is going to be more of an interview because I'm encouraging the audience to ask the questions that you have on mediation and AJS, sorry, so that Lady Justice Jacqueline will answer them tonight. I know we have, there's a statement that I posted, Lady Jacqueline, on LinkedIn, and I said, see you in court. That is a very common statement. Thank you for that comment. That's a very common statement that when we have a dispute, people are quick to say, whether it is in the social circles, not just in the workplace, but in the social circles, and the first statement people make is see you in court. Maybe let me just start by asking you this question. What is mediation and AJS? What exactly is mediation and AJS, Lady Jacqueline?
Yes, thank you very much. I think it's important because, like you've heard, that I'm also a teacher. I do teach. So it's important that for your audience to be able to understand, even when we are talking about what is AJS, what is mediation. So that's why I felt that it's important for us to be able to address this issue, and I'm happy that you have raised it. Now, one of the things that I want to read, and I want to read that article again. So the judicial authority, first of all, we have three arms of government. We have the state, we have the executive, we have the legislature, and we have the judiciary. And any power that we exercise is exercised according to the Constitution. And the people are sovereign. They are sovereign, and they tell us that this is the way we want you to handle our matters. So for the judiciary, they told us, and this is what we said, that judicial authority is derived from the people, invests in them, and shall be exercised according to the Constitution. So one of the things that the Kenyan people told us in 2010 is that they wanted us to start looking at different ways of resolving issues and not necessarily see you in court. Because in Kenya, all that we know is that if anybody makes or has a conflict with you, the first thing that people are going to say is see you in court. And like you've said, Esther Katiba, that's definitely what normally happens. Until you come into the court system and realize how bogged down it is. And so the person who you are actually taking to, who you had a dispute with and you are taking to court, is out there enjoying his life, and you're spending a lot of money using legal fees to be able to chase. Sometimes remember that we're also very few judicial officers, and at the end of the day, these matters end up getting bogged down in court. Not because we want to adjourn the cases, but because if, for whatever reason, because we are all human beings and the matter is adjourned, then you find that then you probably have two shots at a time in any one particular year. So the Kenyan people then told us that we shall exercise judicial authority. And you as the Kenyan people told us that we shall be guided by some of these principles. One of them was that I am required to promote alternative justice, forms of justice. That includes reconciliation, it includes mediation, it includes arbitration, it includes traditional dispute resolution mechanisms. So there are quite a number of things, and we've said including, so it's not exhaustive. So for mediation, and all these processes are outside the court system. So it means then that you don't have a judge who is making a decision. Apart from something like arbitration, where the arbitrator makes a decision, because that's a private judge. But for mediation, you expect a third party, neutral, to come and resolve the issue. But in resolving the issue is that the solution does not come from the mediator. The person who does that is called a mediator. The solution does not come from a mediator. The solution comes from the parties. So the purpose and the role of a mediator is merely to facilitate the discussions between the parties. Because at the time when they're looking at the reconciliation, they're probably not even able to resolve the issues. And in fact, at the very, very beginning, you tend to find that people will first negotiate between themselves. Then they find maybe they're not being able to do that. They probably might have to bring in somebody else to come in, reconcile them. If they're not able to reconcile, they'll probably come to court. But what we're saying, these systems are outside the court system. But even as we say that, And let me also look at the traditional dispute resolution mechanisms, which are now mentioned in 159(1)(c). Now, this traditional dispute resolution mechanisms is what now we call alternative justice system. They are referred mainly as alternative justice system. And these are the traditional ways in which you can resolve issues or disputes, or the informal ways that parties every single day resolve the issues. Now, you will realize one of the baseline surveys that was done in 2017, thereabouts, it found that actually the number of cases that we have coming to court are only 10%. 90% of the cases, even today, were resolved outside the court system. And this is by way of going to the Boda Boda Association. There's a hairdresser association. There is a fishmongers association. There's a market association. So all these disputes, even to going to the chief, they were resolved there. Other people went to NGOs, which deal with children. Other people went to the children's offices. And that's how most of those cases were dealt with. So even the cases that actually came to court were very few. So we end up dealing with about 10% of the cases. And even as we deal with the 10% of the cases, we are still bogged down because we do not have enough judges and enough magistrates to hear these cases. So it's on that basis then that we as a judiciary are promoting. Now, when again I use the word promote, it's very deliberate. That's what the Constitution says. Because these processes are voluntary in nature. Ordinarily, when you have out-of-court negotiations or mediation, then you need to have some sort of agreement, even for arbitration, for you to be able to go outside the court system. Once you agree that you're going to have mediation or you're going to have the dispute arbitrated upon, then there must be something in writing. You cannot come today and tell me you're forcing me to go for mediation. You can't do that. But in court, I can take you to court and drag you in court without your consent. So in these particular ones, you must have some consent. So when the matters now come to court, because we have what is known as a court annexed mediation. So this is now different because in this one, we as a judiciary also sometimes have screening of the cases, depending on the courts where you are. We have the screening and we say these particular cases should go to, ideally for mediation. There are also instances when we find as a judge, as I'm interviewing the parties, especially when you're talking about family matters, then you're likely to tell them to go for mediation. So you see, Esther Katiba and everybody here who is a HR practitioner, yes, it is good that you must also know about HR practices, but also in your own lives as well, because I can see the 7 pillars, you have to be very holistic, is then how do you resolve your conflict? So in that way, that's where we promote. But when you do come to court, in as much as we probably might ask you that, do you think that you can resolve this issue? But we'll still nonetheless, even if one party says, I do not want to go, we'll say, no, you nonetheless go and discuss, because this is a service that we give free of charge. When you come now to the traditional dispute resolutions, the AJS, the alternative justice system, and I look with the traditional dispute resolution, is we are looking at maybe you would look at the injury njeke. How do they deal with their disputes? We have different communities. They have their ways of resolving disputes. I think amongst the Kikuyu, maybe they might have the Kiama where they are going to discuss. I'm not sure whether it is the one, but the Wazes will go there and discuss it, and a resolution will be found. That's alternative justice system when we are focusing on traditional dispute resolution mechanisms. Now, this section goes a bit further and says that these traditional dispute resolutions shall not be in a way that contravenes the Bill of Rights. Let me give an example and say maybe one of the Bill of Rights is to do with children. And it says that you cannot have these children marry when they have not yet attained adulthood. So a dispute where a child probably is defiled and becomes impregnated or is impregnated, then we cannot say that the alternative justice system says that then that particular girl must get married, because that again contravenes the Bill of Rights, because children are placed in a very high pedestal, so you cannot abuse their rights. You cannot also have traditional dispute resolution mechanisms that are, again, repugnant to justice and morality, or result in outcomes that are repugnant to justice or morality. If you look at the previous case, I think it was about 2 weeks ago, where one of the girls, I think, was forced to go and marry an old man in somewhere in the northern part of the country. Now, the kind of dispute resolution mechanisms that were inflicted on the girl were then repugnant to justice and morality, and they are completely inconsistent with the Constitution or any written law. So that is the difference between mediation and alternative justice system. So alternative justice system, we mainly use it as far as a traditional dispute is concerned, is where you have wazés who are doing it. Another aspect of where, again, we have to uphold the rule of law is when, again, we are saying that women should not also sit in the Njorinjeke, for example. So obviously, the men will say, no, we do not want women to sit here because it's against the customs. But for us, the kind of system that we want for the alternative justice system, then it must not also discriminate against women. So in particular courts, we have been launching the alternative justice system. And like in one of the courts in Nakuru, law courts, it's very well entrenched because they even have a course list. So all the matters which are going to alternative justice system. So in Kenya, we want to develop, and also what we have developed is a multi-door approach. So you can either come through mediation, you can even come, even yourself, you can come and tell us that I'm having a dispute with my colleague, but I do not want this matter to go to court. And perhaps maybe you're going to the Employment and Labor Relations Court, because that is where you people are dealing with labor. So in that case, you will go and ask that particular court that you want to be taken to mediation, and the matter will be taken to mediation. For the ones who are in the High Court, like me, will probably be dealing with matters to do with succession causes, will be dealing with issues to do with awards of insurance companies, and maybe there's accident compensation. That's what we'll be dealing with at that particular point. So you also still have a place as the HR in asking for these disputes to be taken to mediation, even court annex mediation. Now, you also have what is known as workplace mediation. Workplace mediation, again, is also where you have a third party neutral who comes and resolves the disputes between employees. It could be an employee, it could be employees, it could be a supervisor with an employee, it could be directors who are having an issue. So you can have also what is known as workplace mediation. Now, but even as I go there, is that perhaps maybe just to say maybe a short thing about maybe the process is that you need to have an entrenched workplace mediation in your institute or in your organization, so that then you're able to resolve these issues. So, but you need early intervention so that this dispute then does not escalate. But normally you find that the employee might request that they want a workplace mediation, but there must also be signs of conflict. So that again, if there's not conflict, because you have to have a difference for you to be able to go for mediation, or where a third party neutral is resolving the issues. But when you're talking about mediation, then it means that the solution comes from the parties. I do not impose a solution, but unlike in the court, there the parties themselves resolve the issues. So I wanted you to understand that issue, and maybe the differences between this particular, maybe like mediation, is that it's confidential. It is, it is, and also the processes, even the AJS, they are very speedy, they are cost effective. And because we have not had what people have discussed, if you're unable to agree, then you can still come back again to court and we'll hear the matter. But I can assure you that most times people will definitely be able to resolve. It might take a little bit of some time, but we ask that parties not to take very firm positions, because in mediation, we call them positions. So if you take very strict positions, then you're not able to resolve the issues. So you're supposed to look at what are your interests in a matter, not necessarily what are your rights. So one of the examples that I can give is that you may find maybe you have an employee in the office but that employee, you're forcing them to stay at the office. So what they can do is that they say that because the dispute is already arising, perhaps maybe the person wants to come to the office, but they do not want to come to the office on a Monday. So you negotiate so that you can have that person coming in, probably putting in extra hours or maybe their flexi hours. So those are the kind of negotiations that you can do, and the matter is also resolved. So I hope that I've been able to make it very clear what AJS is in the aspect of traditional dispute resolution and what mediation is. But again, also, AJS also includes, like I said, those disputes which are taken to border, which have been taken to the chief today, which have been taken to the children's department today, which have been taken to the chief because maybe you are fighting with your house help. All those are labor issues and they did not get to court. So only a very small percentage got to court today. But nonetheless, we are not able to deal with them because of the backlog, and the number of people that we have is not enough. Esther?
Wow. Wow, that's comprehensive, and I see quite some comments. This is great insight and part of professional development. Great to be here, quite insightful. I'll come to Paul later, but Anne says ADR is the way to go because court proceedings take too long and is quite expensive. I'm sure our speaker will speak about it, but maybe before you speak about it, Honorable Jacqueline, let me ask you, what is a legal and policy framework for both AJS and mediation in Kenya? What would you tell us about the legal and policy framework in this country around this?
Now, one of the things that you'll know is that the Constitution is the supreme law in Kenya, the supreme law. So both mediation and traditional justice systems are already anchored in the Constitution. When we come to mediation itself, in our Civil Procedure Act, we have the entrenchment of the mediation, which now is where we now have the court annexed mediation. So this court annexed mediation is where now you will say that, and you can request actually when you have a case in court that I want to go for mediation. Or the court by itself, like what I was explaining, if you see the parties are having, it's easy to resolve this issue. And many times, even when you suggest to them, they'll be like, I think we can actually resolve this issue. You do not want to start fighting with your house help, and perhaps maybe what you need to give, or maybe an employee is maybe something which is very minimal, or even if it's not minimal, it's somewhere which you're going to save because you're looking at your interest. How do you save money for your company? So it's already there in the law. It's anchored in the law first, in the Constitution. And secondly, for mediation, it is there in the Civil Procedure Act. But in most of the laws, and especially when Mutula Kilonzo was there, because he was a member of the Chartered Institute of Arbitrators, he ensured that at least it was entrenched in most of the laws. So you'll find that many of the laws will first state that let people first go for mediation. So different acts will probably have it, but in the court, what we normally probably use is the Civil Procedure Act. Now, when you come to the AJS, it is not, apart from the Constitution, we do not have a legislation. There's no legislation which anchors AJS apart from the Constitution. So what we have was just a policy framework which came out as a result of the baseline survey that was done, that 10% of these disputes are resolved in court and 90% of the disputes are resolved outside court. But currently there is a session paper, and Parliament is also supposed to be looking at the ADR policy framework, because if we have the policy framework, then we can bring all these issues together. One of the disadvantages that we find is that without the policy framework and the ADR policy framework, the broad one, is that people then tend to feel that what is the force of this agreement? Even if I was to go for mediation, how is it helping me? If I was to go to the AJS, how is it helping me? Because it doesn't have the legal framework. But I just want to reassure you is that whatever decision the parties agree, they normally record, they reduce it in writing. So once they reduce it in writing, and especially for mediation, that is normally now brought back again to the court, and we record it as a judgment of the court. And it takes the same format as any other court case. Now, if for the traditional justice dispute systems, it also needs to be documented so that when it comes to court, you are able to resolve and have it as a judgment in the court. So whether a person sits out there, all that they're doing is that they're doing that work and they come and it's already been signed by the parties, then it becomes legally binding. So people should not be worried that they are not being able to get judgment, because it's going to be the same. Once we adopt it, it goes into becoming legally effective. And remember, like I said, that you can also have your mediation outside. You can still come in court and have it registered under miscellaneous file, and it will still have the same force of law.
Good. Now that leads me to this question, Lady Justice. So then, how is the judiciary promoting mediation and AJS in the society? What mechanisms or what platforms and what are they doing in the community? I would really, because when we talk about the traditional ways and the AJS, how is the judiciary coming to us? You know what I mean? How are they coming to the community? How are they doing this? How are they promoting? What avenues are they using to promote this?
Fantastic. Now, remember, our core business is to do decisions, to write decisions. But for us to be able to get into the common wananchi or with the people, we normally operate through what is known as court users committees, CUCs. So here is where you have the local administration, you have the chiefs, you have the police, you have the ODPP, that is the Office of the Director of Public Prosecutions, you have the Law Society of Kenya, you have the faith-based organizations, you have community-based organizations, you have everything. You have the Lands Office, Kenya Forestry, Kenya Wildlife. So it depends on the area or what is the core theme in a particular county. So how do we then sensitize people? Because we normally sensitize now through the CUC, so we probably might have different meetings. We might have sensitization workshops for them, but mainly work through the CUCs. The other thing is that we normally have summits, because I think even recently, or I don't know whether it's something is going to happen soon or it's currently happening, you have like the mediation summit, where the stakeholders all meet and they're able to discuss these issues. So there's a lot of exchange of ideas. When you look at the AJS every year, then all the AJS practitioners, the wazes, the traditional, very, very traditional people do also convene every year. And so they're able to have a stakeholders engagement. So in this way, we are trying our level best. And but I know the different registrars also in the respective places, like the mediation registrar, they do quite a bit of sensitization. Of course, this still needs quite a bit of resources. So we do what we can. But with the training that we are offering, the accreditation that we're offering the mediators, then we expect that these mediators then become champions. But we don't train ourselves because that's not our core business. The mediators will be trained by other people, and I believe that maybe we can address that issue further because that was really not the question that you've asked me, but we engage. And so we also have maybe media blitz. People might write about it in the media and that kind of thing. So that's the way we actually participate. But remember that we are very conservative arm of government. So our job is really not to go out there and sensitize. But within your group, like for me in Vihiga, then I will have my own sensitization programs with the CUC members. And then so that it allows members of public also, or we can even have like under the trees, and we talk to these people, the barazas, so that then they are able to understand what is mediation, so that when they come to court, when we suggest that they can have mediation, then they do not resist. But people resist these processes because they do not know. So even alternative justice system, what we are doing is that quite a number of counties now, even like in Vihiga, we have already launched our mediation center. we are in the process of trying to launch the alternative justice system, the AJS Center. So in this way, then different counties are doing their own launching so that at the end of the day, all the 44 counties will have it launched. And soon, because it's a process that also requires resources, then we expect that at least the entire country will be able to understand. Remember, even when we started, like we were amongst the forefront people. By the time I started doing this mediation and arbitration, it was way in the 1990s, and nobody would even accept it. Even the courts were not accepting it because they felt that it was in their the resolving of the disputes was within the domain of the judiciary. So we believe this is a process. It's going on. It's catching on very fast, and because it's devolved, we believe that each and every place is now going to be really ensure that this particular AJS and mediation is well known in the community.
But I think, Lady Justice, you read my mind, because the next question was actually going to be, how does one then become a certified mediator? And what are the benefits? You know, and I see that's actually who qualifies to be trained. I'm seeing questions, and we will come to the questions. But how does one become a certified mediator, and what are the benefits of becoming that? Yeah.
Now, let me first start with one thing to say this. A mediator does not have to be a lawyer. That is the first thing, because even for lawyers, it also becomes very, very easy for them to become mediators. In fact, even they tend to take positions, because remember them, they are trained to fight for legal rights. So moving beyond the legal rights so that they can become, to look at interests becomes a bit of a problem. But so you find that even that mama boga or the watchman in your compound can actually become a better mediator than anybody else. So that is the first thing. So any particular person, whether you're an HR practitioner, whether you are a policeman, and like even in Spain, I think the police officers are the ones even who do the mediations. Before even the matters go to court, all the matters when they go to the police station, they're first mediated. So now for you to become a mediator faster, you have to be trained. And there are different training institutions that train mediators. I do not want to mention them here, but you can be able to Google and find out which are the different institutions that train. Now, once they train, you can then go, but the basic minimum training is 40-hour training. Everybody has to have a 40-hour training to become a mediator. Now, for you, because we've been finding that sometimes people just go for some sensitization, like today, I've given you a sensitization for about an hour and everybody believes that they've now become mediators. That's not the position. Because if you do that, then you're not going to get a success rate over your solutions. But once you do your mediation and you want now to be an accredited mediator with the judiciary, that is when now you will look and see what are the accrediting institutions, because they're accredited institutions, which if you train with them, then the judiciary is able to accredit you. But you see, that is only limited to the judiciary. But if you do not want to practice the judiciary, you can actually go to any other trainer. But if you now see because these people have to go through a vetting, and if the judiciary then has already acknowledged these particular mediators, then it means then they have value of the kind of things that you're doing, and so that you're able to hit two birds with one stone by having a mediation training through an accredited mediator trainer, and then after that, then you can still be able to do your mediation. So the benefits of doing mediation are very many, because remember, most of us at some point will all retire at some point. And we've been finding even amongst our own judges, when they retire, people are actually going into mediation because it gives you're still doing what you like doing best, being in the space of disputes. But at the end of the day, you're doing something that you enjoy. And it's not something that you're writing the judgments, because you're just allowing people to mediate. Remember that, like I said, you cannot be shoddily trained, because if you do, you're not going to get a settlement. And there are skills. So you're taught a lot of skills in this 40 hours. So it's normally like from Monday up to Friday, that's about 5 days for 8 hours. And that is the standard the entire world over. So if you do your 40-hour training, and even if you submit your documentation, then that institute, wherever it is, would want to know what did you cover in the curriculum. If you're a mediator, remember that you're not only limited to training in Kenya or mediating in Kenya, because Kenyans also need to go beyond that and to see that also when we are mediating the international conflicts, because the Kenyans are not in that space, but many other people, there are a lot of wars which are going on, but we tend to localize ourselves here, but there are very, very many disputes that we can actually go to. In the war, you're going to mediate, because remember, like the last time we had Kofi Annan, when we had the post-election violence coming into Kenya to mediate. So those are things that we can actually do. So there's a lot of potential for it. You can also become a trainer, or you can become a practitioner in yourself. But what we're encouraging the mediators also is to go and also sensitize people, so that by the time, even if the work you're being given from the judiciary is not enough, then you can still be able to generate your own work and make that profession really grow. So there's a lot that you can do, and we can never finish these disputes. And we always say that each person has got their own niche. So you'll have the 10%, they still know about the chief, but they didn't go to the chief, they still came to the court. Then there are those ones who still know about the court, but they went to the chief, for example. Then there are those ones who decided that their matter is not good enough, but I'm still going to go for AJS. Maybe let me go to the traditional system for me to resolve my issue. So there are different ways. So even we believe that even if mediators come, we can never finish work, because the disputes are there every single day. So those are the benefits that I would say. Esther.
Great. I know some people would want to take us into conversations around employment and labor relations in this conversation, but I think I need to make this mention here that next week we are hosting Honorable Mr. Justice Gakeri, Employment and Labor Relations Court Judge. So we will be having another honorable in the room. Now, Paul, I see Paul Ngugi here. Paul is a very good friend of mine, and I saw he did the mediation. And I think, Paul, talk to us. I see you have put in some comments there. Just speak to us. Maybe you can ask your question or give your comments. Paul Ngugi.
Fantastic. Thank you so much. And we are really honored to have Lady Justice Jacqueline. You're really doing a good job.
Thank you.
In terms of the comments, actually the mediation space is fast expanding, which is really good. That means that there's demonstration of very good faith by people. Personally, I'm a certified professional mediator, and I'm a human resource professional in the NGO sector. And I found it, when I attended the training, it really changed my perspective about how we need to do things, both at the workplace and even still in my community, because I also come from Kajiado County. And one of the things that I even realized, even in my own county, is that it's a very effective way, even with dealing some of the issues. And one of the thorny issues, especially in Kajiado County, is on the issues of land. And actually, it has been used a lot. And it was endorsed right from the counties. And it's actually being used, and it actually has resorted to resolving some of the really old cases of land in the county. And even now, coming to the expanding phase of mediation, even in Kenya, I think even for those who are in the mediation space, it's good for you to know also that also there's actually an association of certified professionals in Kenya, which is really good. And it comprises actually of people from very many places. And actually it's meeting from time to time. And I think very well, and I think actually even now, actually, it's actually engaging even the judiciary, so that also actually we can actually increase the spaces for mediation and in overall alternative justice system in Kenya. But I was also looking at especially where human resource actually can handle, actually is the centerpiece of quite a number of conflicts in organizations, and quite a number of issues actually come to human resources, and a number of things sometimes actually go to court. And I actually see an area where it can actually work And actually, my question actually was like, I don't know how what we really can do, especially in the steps that we can be taken to ensure that especially both public and private, because there are certain things which actually end up in court and they shouldn't actually end up in court. And in particular, to embed the alternative justice policies and framework in the operations, and in particular, maybe even just to ensure consistency and alignment with the legal standards. In my view, there are certain things which is you never go to court. And I think Justice Jacqueline have actually mentioned, it takes a lot of time, and it can even cause and even increase the pain over time and for actually years. And the more actually these actually are embedded in the operations, the framework and the policies at the workplace, actually the better. I just want to stop there first. Over to you, Esther.
Okay, thank you. Do you want to, maybe I can just respond to that. And
Yes.
Paul Ngugi, thank you very much for really raising a very, very important issue about Kajiado, because I know Kajiado is one of the counties that has got a very well entrenched alternative justice system with the Wazes resolving the issues of land. And so it has released millions of money back again into the economy. Because I remember seeing the other day how much money has been released. It's over billions, over like 50 billion money, which has gone back again to the economy. And that's how fast the benefits of this mediation are now being seen in alternative justice system. But let me agree with you, Paul, because I agree with everything that you've said, Paul Ngugi. And I think what needs to happen is that people just need to have a paradigm shift in the way they look at disputes or how they resolve their disputes. Because remember, we really don't even need a legal framework for me to decide that we are going to have a workplace mediation policy in place, for example. But I do agree with you that it's important that at least it must be aligned with the legal standards. And again, remember, because of the flexibility of the processes, and I know because you know this, the flexibility of the processes is that one company will probably do it differently from another company because their needs are different. But at the end of the day, when they do come into the legal system, because for us to be able to record those consents or to be able to accept or adopt the agreements, then they must follow particular standards. So I believe, and maybe at that point is where, as a court, we can come back and standardize what is actually coming to court. But I do agree that it's important that we must have an ADR policy in Kenya, because it's not there. That's why you find people resist this, and then we're having lots of problems. Or the way one particular institution is training is very different from another institution, the way it's training. So when mediators also come into the into the space, and also AGS practitioners, if they all have passed through different areas, then you find that one practitioner is doing it differently and not in the correct manner. So you don't even get settlements. And yet maybe Paul Ngugi is getting all the settlements. At any given time, you're always being able to settle because the kind of training that you got is important. So I agree that it's important that, again, we must have those, the framework, also the AGS to be entrenched somehow in some sort of legislation. So I agree with you, Paul.
Thank you. Thank you. I see Samuel has said, great session. What does it take for one to be appointed as a mediator by judiciary after they have been certified and trained through Mediation Training Institute?
All right, Samuel. Okay, fine. Maybe I can just respond. Samuel, is it okay? Yeah. I can respond?
Yes, just respond.
Okay, right. And now, once you are appointed as a mediator, once you're appointed as a mediator by the judiciary, you become an accredited mediator. So there's a register. I think what happens is that then you're assigned particular courts. So perhaps maybe you're told that you'll be doing your mediations in Vihiga, for example. So the other people, you'll do your mediations in Coast Province. Other people will probably be limited to Nairobi. So it depends on the work that is there, because the registrar are supposed then to allocate these matters. Sometimes you find that people will say that I have already finished my training, I've already been accredited, but I'm not also getting work. One is that maybe you might find maybe there's not enough work to go around, because sometimes, like I'm saying, when parties come to court, sometimes they are very resistant to going for mediation. Another reason could also be that they might find that there's a particular mediator who has very high rates of resolving matters. And there's one particular mediator who doesn't even resolve matters. So this could also affect. But I think it's important that maybe a register is kept so that at least there's equal distribution of work. But that is a department, and I think whatever they're doing is fair. And if it is not that way, then somebody needs to write to just find out exactly why am I not being appointed? Because then I think there must be a good reason why maybe that particular person is not being appointed. Maybe there was not enough work to go around. And remember that you're many also now. So by the time you get one dispute, another dispute, it takes time. And also these disputes must be resolved within 60 days. So if you're not able to resolve yours within 60 days, of course, we add you another 10 days. Then we also cannot give you the work because you're supposed to resolve very quickly so that I can close my files. Because at the end of the day, what I'm interested in as a court is how many cases am I closing. If I can have a lot of closing of files through mediation, then it would also be good. The other thing also is that in the place that you're in, you could also approach the court which is nearest to you, because once in a while people do have mediation service weeks where probably they have a cost list of many cases which they want to resolve, and they can call as many mediators as possible. So I would also advise that maybe you get also in touch with the court around where you are in, so that maybe you can probably get enough advice somewhere in Bari. Thank you very much for that question. Very, very important, because it's a very thorny issue.
Okay, good. No, I'm saying Philip. Philip, I think our guest has answered this. I'm doing my internship at the chief's office. Would that be considered as proper internship for accreditation?
Well, it's an important question. It's an important question because you see, whether I don't know what internship you're talking about. Philip, what kind of internship are you talking about?
You can unmute if you're able to.
Thank you, Lady Justice.
Yes.
How are you?
Fine, thank you, Philip. Thank you for your question. It's an important one.
Yeah, my question was, I normally go to help the chief in solving some of the disputes that he has on his table. So I wanted to know if I have the logins and all that.
Do you have you been trained? Have you been trained as a mediator?
Yeah.
You've been trained as a mediator.
Yep.
You've been certified as a mediator.
Yes.
Okay. Yes, because you see, this will help you by the time now you're telling them that I have experience. This is what you're actually telling them, that my experience is in this particular area and I've been doing this kind of disputes and we've been able to resolve perhaps, but it's good always to have documentation, because I know a few other people have also gone to offer voluntary service, maybe at police stations. That shows your proactivity. And I believe it can account for when you're doing your application for accreditation. But whether it will be the reason why you'll be accredited is a different issue, but you need to also show that you have been in that space. But I believe for me, if I was in the accrediting committee, I would think I would recognize that as well. But of course, they have their own procedures, but I think it's a good thing to have. But
thank you.
Document it, yes.
Hey, can I say something, Justice?
Yes.
Yes, you can. Yes, you can.
Yeah, I think these are very good questions, and this is a good forum. My name is Agola, and I'm with the PCA JPRC Department, Justice, Peace, Reconciliation, and Creation Department. I'm an accredited mediator, and I've gone through all those processes. I think what answers you are getting to your questions is that, one, you have to be trained and certified. Two, when you go for whatever you call maybe internship or to be practicing this mediation privately before you are accredited. And so your question is what I've done before accreditation recognizable at the Mediation Accreditation Committee? The answer you have been given is yes, because how will they know you have done some work if you have not done it? So you first do that work, but you ensure as you are being encouraged to come with a recommendation from whoever was supervising you or whoever gave you the work, and you come with that recommendation to show that you actually did the work. What are you not coming with? You are not coming with the agreement that was written, because that agreement in your training, you are told it is confidential. So the committee that is doing the interviews are not interested in that agreement, but they are interested in your narration of what the case looked like and how you resolve, whether it was partial or full agreement. And so you need that proof that you are actually there. And when you are in your interviews, please do not contradict yourself, because sometimes you may contradict yourself. You said this date in the written form, but when you come there, you begin to say another date. That means you are not genuine. I thought I would add my voice to that, but I would also say that when you are accredited, you are accredited, but you have to keep that accreditation. Some are passive, some are inactive, others are active, others are under mentorship. That means that you still need to do more. And so this is a good forum for us to learn. Thank you.
Thank you so much, Dr. Agola. He should have become my core panelist today. That's what he has told you is very, very correct, Philip. Yes. And maybe just for me to add is that one, he said you have to be trained and certified to be accredited, isn't it? But in addition to that, I want to say, if you're trained and certified, you do not have to be accredited by the judiciary for you to practice to be a mediator. But if you want to be accredited to be in the judiciary, then you have to go to be trained by the institutions that have already been accredited by the judiciary, and which is what I can see the next question, which was being asked, that which are the accredited institutions in Kenya that offer mediation courses. Now, there are very many different institutions, and that's why I do not want to mention any here, because I do not want to be accused of advertising some and not mentioning others, but there are very, very many accredited institutions. So the good thing is that please go to the judiciary. They can give you a register and a list of all the accredited institutions, and more so if you want to, because those institutions which will be accredited there are mainly the ones that offer mediation courses. But as you continue engaging in that space, then you'll also probably come and find out that there are others. Remember, like for me, I told you that I was also trained in the US. So you can be trained wherever you are. But for you not to be accredited to the judiciary has said 1, 2, 3, 4, you need to have been trained by these 4, 5 people or 6 people, and for you to be able to work for us, because then they can be able to trust the curriculum and they can be able to stand there to trust the standards. Remember, like I said, that some people who say that they're mediators, they take you maybe for about 2-3 hours of training, then they say that you've already been accredited as a mediator. But when you go to practice mediation, you're a disaster. So like Philip, it's better to still go out there and practice. There are many women organizations that have places where you can practice before you actually go to become accredited. The other thing also, you can also have other different accredited institutions that also offer forums for mentorship, so that you are given some sort of like pupillage. So when there are other mediations going on, then you can be called. But remember, because mediations are confidential, the parties must have to be asked first whether they have any objection in you being in that session, because it's confidential. But if they say they really don't care, like when I did my training when the US, they had to be asked first, and they said, I really don't care. I mean, if they're learning what they need to learn, because you're not going to spread the information out. So, and that now goes to the next question for Jane Degwa, when she was asking, then who qualifies to be a mediator, to be trained? Remember that I said it's not specific to one profession. Any person, so long as you feel that you can be a mediator. You see, for you to be a mediator is that you have a skill to be able to resolve, to help people resolve issues. You see, there are some people who are very good in that. Then there's some other people who are also very good in training. Then there's some other people who are very bad because once they come into a dispute, they will even add fuel. So those ones do not have the calling, but it needs a lot of patience, because when you're speaking to these people, especially like sometimes when you're talking about family matters, especially you're talking about custody, you're talking about maintenance. And many times you will probably find that what they're talking about is petty, but it is not petty to them. It is what is concerning them. So you have to be very objective, not subjective, because you have to be neutral. You cannot take any sides. You cannot even like in arbitration, we cannot have perception of bias, because if you do that, they will reject. Yet we are still telling them in mediation, you do not come up with a solution. But at the end of the day, they will still say, we do not want this mediator. So you also don't want people to be recusing themselves and telling you to, asking you to recuse yourself from matters. So I think that was the next one. All right, there's somebody who is Matson, is also going through training by MTI. So you see, there are people who are they're also telling you in certain ways where you can get your training. So there's a person who is doing it at MTI. So there are very many. So Matson, maybe you might be able to assist the other people in knowing where it is, because I don't want to mention any particular one so that I do not look like I'm biased. And then, isn't it? I don't want to look like I'm biased. But Jane Dego, I think you've also asked that after being accredited as a mediator, can one choose the area to arbitrate? For instance, as an HR employer area would be much preferred. Now, as a mediator, let me differentiate this. As a mediator, you do not need to have professional or academic knowledge of the dispute that you're resolving. So that if I'm a mediator today and I'm a lawyer and I do not have any HR experience between an HR employee and an employer, I can still come and mediate that matter. I can mediate that matter. But of course, it could be preferred because then maybe you understand the intricacies, and when you are asking maybe them to discuss what are the alternatives to this negotiated settlement, maybe you might ask open-ended questions for that employee to consider. Maybe you can say, have you considered how much you'd be losing, or have you considered how much maybe you probably get if you continued working for the next 5 years as opposed to resigning now? You see, that maybe I'll probably be saying because I understand the dynamics. But even if you do not understand the dynamics, you can still ask that person, have you considered why you would want to leave at this particular point and maybe how much money you're going to lose? Have you considered how much money you're going to lose if you exit at this particular point? So you can still ask the question in that way. But some people decide because they really like HR matters, then they concentrate around that area. There's still no problem. Because some people say that I enjoy dealing with the family matters as a mediator. They probably enjoy dealing with divorce matters, not divorce matters, custody matters or maintenance. That could also be your forte, so you enjoy it. And maybe when you're being given, maybe like if you're acting in the judiciary, you can ask perhaps that's the area that you want to be attached, maybe the children's court. If you yourself have your own business, you can also have a niche and say, I'm only going to deal with employee-employer. That becomes your niche, and we are going to deal with it. But I want to differentiate it to mediation, arbitration, because you can see there, now you have used two words. You have used mediator. After being accredited, can a mediator, can one choose the area to arbitrate? Now you see, when you use the word arbitration, it is not correct in that format, because arbitration is a totally different format. So in arbitration, you have to be skilled in that area. So if we are going for arbitration because of an engineering dispute, and it's an engineering dispute that's what we are going to discuss, or a structural engineering problem, or something to do with architects, then the person who is a mediator must then ordinarily be an architect. You won't be appointed if you do not have expertise in that area. But a mediator, you can be appointed in any area, because what you're using are the skills to be able to bring these people together, not really the knowledge of the dispute. But if you know the knowledge of that dispute, it is still good enough because you can guide them, push them towards getting a settlement. But remember, you're not supposed to suggest any solutions. What you're supposed to do, you're supposed to ask open-ended questions and let them come up with their solutions, but not you telling them, but you know you're not going to lose 5,000 if you leave. No, you ask it, have you considered how much you would lose? So that that person is actually thinking about it. You're not the one who is guiding them towards that. Okay,
Justice,
yes.
can I say something also there?
Yes.
Yes, I think the mix of the word mediator and the word arbitrator is a clear indication that all of us in this forum need pupillage, need mentorship, but again, getting it from the right people is the right thing. Because when you go through that rigorous training for 5 days, or online training for how many days, or maybe every Saturday, some institutions organize that, you may not get these concepts right. The reason why you can mix them, the reason why you can ask questions that touch on them, and need for such forum, including proper mentorship, will help clarify most of the terminologies that were used, or some of the terminologies that were explained, maybe when you are there, or when you are not there, or you did not get them right because of the intensity of the time. And so again, as the facilitator was saying, we need to go to the right people to help us get the right information and the right scale for us to be good mediators. Thank you.
Thank you very much, Dr. Gola. Just maybe to add that the way that maybe then we can say about mediators facilitate. They facilitate the mediation process. Then the arbitrators not they arbitrate, because it's a decision which actually comes from the mediator. But the other one is the parties who are going to agree once they are facilitated. Now, I can see Nehemiah and Ndiritu is raising the hand, but let me just deal with this issue of criminal cases. Now, Andrew, it is also good to mention that mediators don't deal with criminal matters. Now, this has been the way that Kenya has been going, but it's because the issue of restorative justice is also a new area. Because if you actually look at the place where I was trained, like in the US, a lot of mediations take place in the criminal matters, but only particular criminal matters. And like I know, even like in my court, we have quite a number of matters that are referred to the chiefs when they're already criminal cases. But they're a particular category, then you cannot, we cannot just tell a mediator, go and do this, because the republic is the complainant. But we also find that there are many cases, when you're talking about restorative justice, is where you find like somebody has stolen your vegetables, for example. So instead of having this person taken to court, the parties then can still agree to go to a mediator, and you agree that you're going to come and probably dig that person's shamba. So that has been dealt with by a mediator, and they do come up with a solution, and they say that this is what we want. For me, we have agreed I'm not going to pursue this matter. This person is going to be digging. But I agree with you, Andrew, that you cannot deal with criminal cases unless the court obviously has forwarded. So you cannot decide to go out there, you have your own mediation outfit, and then you tell all the criminals to come and mediate. That is not allowed, because the Office of the Director of Public Prosecutions is the one that decides who they're going to charge and how they're going to charge. And remember also, we are also having what is known as diversion when it comes to the Office of the Director of Public Prosecutions. And at that point, maybe they may want to send certain matters, even if they're criminal, for mediation. But you're right that don't deal with the criminal matters until it is necessary for you to deal with. And this is what we were talking about, even those repugnant cases. But you'll also find in certain communities also, from what I've heard, is that once they agree, say a woman has been killed, you get 5 cows or 5 animals. When a man is killed, they get 7. The compensation is maybe 7 animals. It's even the discrimination that is there. So that is what the court will not come and endorse. But you'll find on the ground, people have gone, they've discussed, but mainly that is in AJS. So it is repugnant even to the laws of what they're doing. But we have realized that even when we are in those particular courts, even if you ask these people to come and give evidence, they will never come and give evidence. So these matters just end up wherever they are. So you find that people are doing those kind of things there. The only one that we will not accept is for defilement. If people go and have kangaroo courts and mediations where children are involved and there's defilement, that is not going to be allowed. So that also becomes a criminal offense because the child is not able to give consent because they are below 18. And in Kenya, you can only give consent when you're older than 18 years. So let me go to Nehemiah Ndiritu, I hear, and then who is it? Because I was appearing as Nehemiah there. Where is Nehemiah?
Yeah,
He's disappeared.
I'm here.
Okay.
And thank you, Lady Justice.
Yeah.
I was listening to you when you were talking about asking open-ended questions. And maybe you mentioned something. I request you mention something about when you're asking open-ended questions. It's good that you don't again mix the various methods of mediation. I'm a CPM, a certified professional mediator. Because I think we have many types of mediation methods, evaluative, facilitative, which you have talked much about. You also have transformative and narrative, but maybe mention something about when you are asking open-ended questions and trying to encourage these disputants to arrive at a mutually agreeable solution, you don't mix the methods of mediation.
That's correct. Today, I'm very, very happy. You see, Esther Katiba, and this topic is very good because we have a lot of people who are very well versed. That is true. And that's why training is very, very critical so that you're able to be able to differentiate what exactly you're doing and what exactly are you, which method you are actually approaching. Similarly, also, when you're doing also the open-ended questions, remember that also there are also what is known as closed questions. So the open-ended questions are mainly for you to explore and to get as much information as possible from the parties. So, and all these are things that you're now trained during the training, the 40-hour training. You're also told about how to reframe the questions, how to rephrase the questions, how to summarize what people have said, how to rephrase, how to reframe. You know, all those are things that you're taught. And that's why we're saying that it's important that people are able to understand the different mechanisms and the skills, because if you don't have it and you go to a mediation and you start asking somebody, you're called Nehemiah. So the person is like, yes, because that's a closed question. You work in Nairobi, yes. But if you ask somebody, Nehemiah, please let me know what is your name and what do you do? They're likely to give you a lot of information for which now you can be able to use. So there are different techniques and different mechanisms that you can use. So let's all say that we should be trained. So for Esther Katiba, I say that it's important that perhaps maybe either in your institution or your conversations, people are able to also have this kind of training. It will be good. So that we are all, but this is just maybe for sensitization. Maybe people can have a longer sensitization, or they can even be directed to where they can go, because it's a good field. For me, I'm passionate about it, and as much as I'm a judge, I'm still very passionate about mediation because it pushes the matters away and retains the relationship of the parties. The parties end up becoming friends. But if you win in a court case and the other person becomes a loser, issues are that you will never speak to that person again, and you will wait for them. The next time, you will wait for them to revenge. But when it comes to mediation or AJS, people shake hands. They say, yes, we have agreed. The issue has been resolved. The traditional people might say, let us slaughter a goat, they eat a goat. The mediators might be like, let's have a handshake. And from then on, someone maybe probably just wants an apology, and that's all. So there are different solutions that you can get, which come from the parties. Unlike in the court, where I'm only going to give you a decision which is going to make one person to suffer. I think when I look at all these questions, I think I have answered all. But just to say thank you very much to all the good comments that you people have given me, saying that it's inspiring, it's you want to learn more, you continue to learn. That is true, because we can never be experts in any field, where we always must have a way to learn. Now, maybe as a final comment, this is what I'd like to say, that you see, there's a spectrum of dispute resolution mechanisms. There's a spectrum. But in Kenya, we always start at the end. And where we start with see you in court, and everybody starts at see you in court. But what they're forgetting is that you also have those negotiations, what you've had them talk about evaluative. You're talking about this conciliation. There's so many processes before you get to court. But as Kenyans, we tend to go to the last one. And that's the reason why we have gotten bogged down in that place. So it's good that we learn all these processes, because it becomes like a toolkit. When you, as a mediator, you want to use this one maybe to resolve a dispute, you remove the one for mediation. Again, it's important to also learn how do you do conciliation, because it's also different. And what are the principles of conciliation is different. If you're doing arbitration, it's also different, because it's also another area that you can also come and earn money and do it at your own pace, even before you get to court. So that is what I would like to say. So the issue is not see you in court. The issue is that let's see how much we can resolve ourselves. I can see another question there which has come. Who I think this maybe. Thank you so much for this. So that's Pauline Murathi. Thank you very much. Yes, very good that somebody has said I've unpacked in a practical way the AJS. Yes, that's all that it is. Because you don't want to make it too complicated, because remember that the people you're dealing with are people on the ground. So you're dealing with border people. If you're dealing with the issues, how are they resolving their disputes? Because their disputes are resolved, then they move on. Or they'll ostracize you from that place. They have their own self-regulating ways of doing it. But the AJS, which is also in court, the one which is court annexed, and even the court annexed mediation, is that then we have rules as to how we are going to be able to do it, so that then the people are not doing things all over the place. There must be some order. So even when the borders are doing, even like, especially like in Nakuru, there's a structure in which that is followed. But every year, and even this year, I do expect that there's going to be a stakeholders engagement where everybody person goes. And I remember last time when we went, we had a fireside chat. And so we also, even as judges, were able to ask some of the traditions that we see whenever we are going out in different counties to deal with our cases. Like the one which I told you, once the people have been paid, they will never come to give evidence. So you'll be stuck there with a murder trial for many, many years, but people have resolved and they've moved on. So you're forced to close your file. Thank you very much. I think I have finished this, and again, once again, just to really thank you for taking the time out to, when people are very, very tired in the evening, to listen to me. I am completely humbled. Thank you very much.
Thank you, Judge. I would want to thank you for having taken your time, and that was very educative. I shared your link with many people, and I saw they joined, and some have asked questions, and that is very, 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 very good. I think you have enlightened us, and especially those who asked questions, and this will be very, very good. I would want to urge that all of us who are here and are aspiring to train as mediators, training is the first thing, so that you get the skills, and then when you now begin to practice, you can be guided as Judge has done this evening. Thank you. You can reach us. We can also help you because we also do the training. Thank you.
Thank you very much, Dr. Agola. And thank you, everyone. That's actually our sessions, Lady Justice, end at 8, but today is a different day. And it is important to allow people to keep learning. Now, for the audience in the room, this has been Conversations with Esther Katiba. You can find us on our YouTube. This session will be on our YouTube immediately after this. Our YouTube channel is Conversations with Esther Katiba. You can find me on LinkedIn as Esther Katiba, Instagram at Conversations with Esther Katiba. So just type Esther Katiba. Thank you, Lady Justice Jacqueline. It's been a great honor hosting you. And let's meet here next week, Wednesday. We have our sessions every Wednesday, 7 to 8 p.m. We will be hosting Honorable Mr. Justice Gakeri from the Employment and Labor Relations Court on the topic navigating termination at the workplace. It will be an amazing session. Let's keep our eyes on our social media. Keep your eyes on my LinkedIn, Esther Katiba, and our other social media platforms. Lady Justice, thank you, thank you, thank you.
Before you move, before you
yes.
finalize, I just wanted to mention that the views that I've expressed here are mine and are not representative of the judiciary because I'm not the spokesperson. So those were my views. That's the disclaimer I wanted to make. Thank you.
Thank you. Thank you very much. Thank you, everyone. Have a good night and God bless you. See you.